crazy before by 7-year-olds. But what they can't justify is an across-the-board ban on all firearms in all places for all residents at all times. That's not a reasonable restriction. In fact, it's not a restriction at all. It's an out-and-out prohibition. And both the D.C. Circuit Court and the U.S. Supreme Court agree. So that's a little bit of background on the case. And what I'd like to do now is to give you some flavor of the anatomy of a real-life lawsuit, how these things come about, how the litigation unfolded from a practical perspective. And I think you'll be interested in particularly the NRA's role in all of this. So we litigated this on what's called as a public interest law. Public interest lawyers don't get paid. We represent clients who typically can't afford to pay us. The nice thing about being a public, the not so nice thing is the nice thing about being a public interest lawyer is you can, whereas private for-profit lawyers cannot, instigate litigation. We can go out and try to drum up litigation. We can run a full-page ad in the New York Times. It says, we really have a pet peeve about the government's position on the Second Amendment. We want to litigate. Are any of you folks out there willing to be plaintiffs? Now, you're not supposed to do that. You're not supposed to instigate litigation if you're a for-profit lawyer. But I suppose the theory is that since we're not getting paid, there's no perverse incentive for us to drum up frivolous litigation. Another interesting thing about public interest law is that you can litigate the case, or you can actually argue the case in two different venues, two different courts. There is, of course, the law court, but there's also the court of public opinion. Even if you lose in the law court, if you can get the public on your side, there's a pretty good chance that you get legislative relief. And to digress for a moment, if you want an example of that, probably you've heard of this case up in Connecticut about eminent domain called Kelo versus the City of New London. It was a huge loss in the Supreme Court. The case involved taking Mrs. Kelo's home and the home of her neighbors. Why? So that Pfizer could build a pharmaceutical plant and some private developer could put up hotels and office buildings. And the Supreme Court actually said, even though the Fifth Amendment says you can't take private property except for public use, the Supreme Court said this would be okay. It may not be a public use, but it is a public purpose. We're creating jobs, and we're increasing the tax base. So nobody's home is safe from the government bulletin. This was a huge loss. But what did the law firm do, the public interest law firm? After they lost the case, they took it to the court of public opinion. And as a result of the media crusade in 43 states now that have overturned the effect of the Supreme Court case, at least with respect to state law. They can't overturn, of course, federal law. But with respect to state law, now these 43 states give you more protection as an individual homeowner than the Supreme Court is willing to give you under the federal Constitution. So that's two good things about being a public interest lawyer. You can instigate litigation, you can go to the court of public opinion. And what it means is that when we look for plaintiffs, we want to present the very best case possible, both from a legal point of view and from a media point of view. And so our criteria in searching for plaintiffs, among other things, we wanted gender diversity, we wanted racial diversity, we wanted economic diversity, we wanted age diversity. We had to have D.C. residents who fervently believed in the right to defend themselves in their home. Not just mouth the words and say, we think we would like to have a gun. They got to feel that they're at risk, that they're unsafe, and they really do need a weapon, because that is the best story to present to both the court and to the media. And they had to be articulate, because we knew that they would be dealing with the media. So net result, we picked people with good facts. Mr. Heller, I mentioned, guarded a federal office building, carried a gun all day. Mr. Parker was threatened by drug gangs, and Mr. Palmer was accosted by an homophobic thugs. We interviewed dozens of plaintiffs to come up with the six that we liked. 3 men, 3 women, they ranged in age from the mid-20s to the early 60s. 4 of them were white, 4 of them African Americans, ranged in occupation from a communications lawyer to courthouse security building. With respect to funding, there were offers of funding from the usual suspects and various gun rights groups, but we didn't want Heller to trade its litigation with the gun community responsibly. Not that there's anything wrong with the gun community, but this was more compelling and more convincing that it was sponsored by persons who were not affiliated with the gun community and afraid of us, who litigated the case. Were not affiliated, so we rejected offers of funding, and we decided to provide the funding ourselves. The litigate in Washington, D.C.? Washington, D.C. was a unique and appropriate venue for a number of reasons. First, the rate of gun violence in D.C. was just about the highest, or the next to highest in the nation. Second, D.C. had the most restrictive gun laws of any major city. So here you have the perfect combination of litigated case. The very most restrictive gun laws and the very highest rate of violent crime. Third, and very important, the applicability of the Second Amendment to the states had not been resolved. So all we knew was that the Second Amendment might apply to the federal government, but we didn't know whether it would apply to the states. And so by bringing it in Washington, D.C., which is a federal enclave, it's not a state, we can get rid of that nasty subordinate problem and let the court focus on the important issue, which is what does the Second Amendment mean. And then finally, D.C. is where the federal government lives. And that means that if you have a Second Amendment challenge you want to litigate, you can always litigate in D.C. D.C. is always an appropriate venue, a proper place to bring a lawsuit, because you can always sue the defendant in the place where the defendant lives. And that means D.C. was the most important of all the judicial circuits, because even if a infraction, even if your rights were being violated in Utah, you could litigate in Washington, D.C., and so a victory in D.C. about the meaning of the Second Amendment would effectively have an impact on cases that arose out of violations of Second Amendment rights all across the country. The approach was an incremental approach, and that is, by that I mean, don't bite off more than you can chew. So this is the same thing that Thurgood Marshall did when he litigated the civil rights cases. So Heller was a straightforward constitutional challenge to D.C.'s gun laws, and it was all about a handgun in the home. So it didn't get involved in more elaborate weaponry. It didn't get involved in outside carry. It didn't get involved in any statutory infractions, procedural infractions. It was a very basic case. And now what I think is some just interesting history about the NRA. The Cato Institute, where I chair the board, often is allied with the NRA on gun rights issues. Sometimes we're not. We have some disagreements about some non-gun issues, and we have even some disagreements about gun issues. But in any event, we have a working relationship, and so we notified the NRA when we decided, the three of us decided to do a case. The NRA said, don't do it. Why? Well, because it's really a good case, and you've got great facts and great plaintiffs, and you may win in the appellate court. And we're a little bit worried that we don't have the horses on the Supreme Court, so you might win the battle and lose the war. Now, it turns out the NRA wasn't far from wrong. This was a 5-4 decision, so it's not as if this was a slam dunk. And it was pretty clear which way the Supreme Court was going to go. It wasn't clear at all. So I attribute this to a heartfelt belief by the NRA that it was a real risk to take this up to the Supreme Court. Well, we didn't follow their advice. We thought the Supreme Court was pretty good, and we were worried about other cases going up, challenging the Second Amendment where you have a crackhead or a bank robber as opposed to for the Second Amendment. We didn't want that. And there was this fact, that even if we lost in the Supreme Court, that doesn't mean that the states can't give you more rights than the federal government gives you. And as you folks know, 47 states have concealed carry. 49 states have concealed carry. It's only Illinois right now that doesn't have concealed carry. So under state law, even if you lost on the federal side, under state law, there's a great deal of protection for gun rights. For those reasons and others, we went ahead and decided to litigate, even though the NRA decided had urged us not to litigate. Well, the NRA decided they didn't want to stand on the sidelines and march 3 guys that weren't connected with the NRA, litigate the most important Second Amendment case, come down in 70 years. And so the NRA filed a parallel case, a copycat case, in the same court, raising the same issues with 5 different plaintiffs. And then they moved to consolidate the 2 cases in an obvious attempt to take control of the litigation. We resisted that, and that took 3 to 4 months. And a separate case involving whether or not to consolidate, and we won that case. So the 2 cases, their case, which was called Seegers v. Gonzalez, and our case, which called, however, Columbia. The two cases were not consolidated. They both moved along on a parallel track. Now, the way it works in court, in the federal court, is your case gets assigned to a U.S. District Judge. The assignment is random, so you don't know which judge is going to get your case. And these judges have varying levels of energy, varying, their dockets are not all equally busy, so some of them move quickly, some of them don't. We filed a case months before the NRA. They filed months afterward, and yet they got the decision before we did, even though their case never even got to the judge until months after that. They lost in the district court. So they appealed to the Court of Appeals. And while they're appealing, we lose our case in the district court to a different judge. A judge who had the case a long time before the NRA case, but he took his time. And we appeal. And then the appellate court says to us, we're going to have to postpone your case because there's no sense in our dealing with both of these cases. They both raise the same issues. They're both in the same court. And frankly, if we deal with the NRA's case, which got here first, it's going to dictate the outcome of your case. And if the NRA wins, you win. If the NRA loses, you lose. So there's no sense in taking both cases. So we were dead in the water. And the NRA had accomplished exactly what it intended to accomplish, which was to take control of the litigation. And then the NRA loses in the appellate court. The appellate court allows us to go forward. Now, why would they do that? I mean, why, if the NRA loses, doesn't that take the outcome of that case? Because the appellate court in the NRA case never did get the Second Amendment issue. It never even addressed the Second Amendment. What it decided was that none of the 5 plaintiffs had standing to sue. Why? Because they were not injured. All they said was, we want to have a gun. They didn't go out and get a gun. They didn't apply for a gun. They weren't prosecuted for having a gun. So they were not injured. Their injury wasn't sufficiently credible and imminent. Those are the standards. They have to be injured in order to bring a lawsuit. So, because it didn't reach the Second Amendment, our case was allowed to go forward. 5 of our 6 plaintiffs get thrown out for the same reason. No injury. 1 plaintiff survived. Mr. And that's why the case changes its name from Parker versus Bishop to Heller versus. How did Heller get standing? He's the only one that applied for a gun permit and got turned down. That was his injury. He didn't have to get arrested. All you have to show is that you're injured. And if you apply for a permit and you get rejected, that's an injury. So Heller could show that he was injured and therefore he had standing. Now you might say, why were we so stupid we didn't get the other 5 guys to apply for a permit? And why was the NRA even dumber than we were? They didn't get anybody. And the answer is, it's catch-22 in Washington, D.C., and this should show you how absurd the law can be at times. And the law says, if you want to apply for a permit, you can't do so in Washington, D.C. on an imaginary gun. You have to have a gun in order to apply for a permit. But you can't get a gun in Washington, D.C. There's an outright ban on purchasing guns in Washington, D.C. Why not go to Maryland or Virginia and get a gun? Well, because federal law says you can only buy a handgun in the state where you live. So, in order to apply for a permit, you have to have a gun. And in D.C., you can't get a gun. You can't get a gun in the neighboring states. Net result, no application. No application, no denial. No denial, no standing. No standing, no lawsuit. So how did Heller do it? He got a gun a decade earlier when he lived outside of D.C. He moved back to D.C. He couldn't bring the gun because that would be illegal. He could bring the paper. So he could prove he had a gun. And that was sufficient for him to apply for a permit, which was, of course, denied. It was a rubber stamp process. Nobody got a permit. And that meant he had a standing. And so his case would go forward, even though our other 5 plaintiffs did not go forward, and none of the NRA plaintiffs did. So we thought the NRA was finally on board, but it was not. The NRA then, finding out that they could not proceed with the case, the court went to Congress and tried to get the D.C. gun ban repealed.